Uh, so my name is Christian Burset. I'm an associate professor of law at Notre Dame. We also have Greg Ablavsky, associate professor of law, and by courtesy, associate professor of history at Stanford. And his book is coming out later this year from Oxford University Press. It's titled Federal Ground, Governing Property and Violence in the First U.S. Territories. Next, we'll have Will Smiley, assistant professor of humanities at the University of New Hampshire. He also has a book from Oxford University Press, published in 2018, titled From Slaves to Prisoners of War, the Ottoman Empire, Russia, and International Law. And finally, we have Yahaya, assistant professor of history at the National University of Singapore. Her book, Fluid Jurisdictions, Colonial Law and Arabs in Southeast Asia, was just published by Cornell University Press. So we will speak in that order, which is roughly chronological, and we should have plenty of time for questions at the end. At that point, just either please use the raise hand function or send a chat or gesticulate wildly, and I will recognize you. So I will kick us off. So my paper is about legal transplants in the British Empire, and specifically about how a group of imperial policymakers came to believe in the last third of the 18th century that some kinds of law were more suited to transplantation than others. The conclusions that they reached may not surprise comparative lawyers today. So these 18th century policymakers decided, for example, that family law was uniquely local and that commercial law was especially suited for transfer. And that's very similar to the orthodox view articulated by comparativists in the 20th century and anticipated to some extent by people like Maine and Savigny in the 19th century. The more interesting part of the story is how those 18th century lawyers arrived at their conclusions. So despite broader trends in the field of comparative law and in legal history, the study of legal transplants is often told as intellectual history. So one starts with a big thinker, Montesquieu, for example, who then develops a theory that then later gets picked up by policymakers, perhaps in the context of imperial administration. The paper today tells the story of legal transplants not as a matter of intellectual history, but as a political history. It argues that imperial policymakers developed their theory of legal transplants in the context of a debate about whether to impose English law on newly conquered territories. The idea that commercial law was more transferable than family or property law emerged as part of an attempted compromise between politicians who wanted to export English law to Britain's colonies on one side and those who favored a more legally plural empire on the other. The lawyers who promoted this compromise were familiar with Montesquieu, but their conclusions depended much more on imperial politics and policymaking than on theoretical deductions. So the rest of this talk has three parts. First, I'll give a little background about the 18th century British Empire and on why legal transplants became such a salient issue at that time. Then I'll talk about how British policymakers decided that some branches of law were especially amenable to transplantation. And finally, I'll return to why this matters. I'll suggest that this story sheds new light on the discipline of comparative law. In addition, the story highlights an important connection between comparative law and the history of the common law. The experience of thinking about legal transplants, I'll argue, helped to reshape how English lawyers thought about their own legal tradition. So the first part, background. In the second half of the 18th century, the British Empire expanded dramatically. Even as it was losing control of what would become the United States, it seized several colonies from France and Spain, including Quebec, Senegambia, Florida, and several West Indian islands. It also acquired de facto control over Bengal and other parts of the Mughal Empire. Britain transplanted English law to most of these places, but in Bengal and Quebec, it adopted a deliberate policy of legal pluralism, partially introducing English law while continuing to administer Hindu and Islamic law in the former and French civil law in the latter. So why were Bengal and Quebec treated differently? In an article I published last year with the Virginia Law Review, I showed that this outcome was the product of debate between different visions of colonial development. One group of politicians, I called them Tories, wanted Britain to withhold English law in order to keep those colonies culturally isolated, economically dependent on Britain, and politically docile. Another group, which I called Whigs, insisted that Britain should govern all colonies based on a common law that would reflect and promote the equality of all British subjects. Britain ultimately imposed legally plural systems in some places because Tories won that political fight. During that debate, a group of moderate Whig lawyers tried to broker a compromise. They suggested that Britain might introduce English law for what we would today call civil procedure, contract, and tort, while preserving more pluralistic regimes of property, inheritance, and family law. Now, at one level, this looks a lot like the continuum of transplantability that's familiar to modern scholars. So, for example, Ron Harris and Michael Crystal have offered several conceptual reasons why it was unsurprising that the British Empire wanted to transplant English commercial law to mandatory Palestine. And family law has often been assumed to occupy the other end of the spectrum as the kind of law most thoroughly embedded in social and cultural power structures, and therefore the least transplantable. But on closer inspection, the Whig compromise starts to look more puzzling. As Otto Kahn-Freund observed, the transferability of a particular area of law is historically contingent. So he cited Montesquieu for the notion that family law was especially transplant resistant, but he also observed that by the 1970s, family law had become the prime example of successful cross-border harmonization. Civil procedure, in contrast, served as his key example of failed transplants, which is exactly the opposite of what Whig lawyers proposed. Meanwhile, his antagonist, Alan Watson, simply denied that some branches of law were especially unsuited for transplantation. So then we can't just assume that Whig lawyers were doing the obvious thing when they came up with their own version of a continuum. Instead, we need to ask where they got their ideas. There are three possibilities. First, it's possible that they were reacting to the perceived preferences of colonial subjects. So maybe Whigs thought that Canadians and South Asians were especially attached to their own family law, but were more open to change when it came to the laws of contract or procedure. There is some evidence to support that hypothesis. Colonial officials often reported that Canadians and Bengalis were especially protective of their customary family arrangements, but that they were often willing, for example, to serve on juries. We also have surviving petitions from Francophone Canadians and South Asian merchants asking specifically for an English-style trial by jury or the introduction of English commercial law. But there's also evidence that the preferences of colonial subjects weren't the only consideration. The best example of this comes from the pen of a man named Fowler Walker, who was a Whig barrister who served as a London lobbyist for Anglophone merchants in Quebec. Walker acknowledged that French Canadians might object to what he called the tediousness of English civil procedure, a word that my students of Civ Pro would probably agree with. But Walker dismissed that concern by saying, quote, they should consider those delays as the price which they pay for and the criterion of their liberty. Now, he attributed that sentiment, by the way, to Montesquieu, although Blackstone said something very similar in his commentaries. Walker and his allies also supported the imposition of English criminal law in Quebec, despite evidence that some Canadians disliked it. So something else had to be going on besides the perceived receptivity of colonial subjects. A second possibility is that Whig lawyers were riffing on categories familiar to them from common law jurisprudence. English courts had long used a uniform set of procedures to administer different local customs concerning land tenures and inheritances. So for example, if an English judge could handle a case involving Kentish gavelkind, perhaps a Canadian court could do the same thing for French land tenures. But this explanation also seems incomplete. Most importantly, not everyone at the time agreed that substance and procedure could be severed, or that it was even possible to think in terms of those categories. For example, one member of Parliament, Sir William Meredith, insisted that the civil law of France and the trial by jury in England are so dissonant that the forms of one can never be blended into the proceedings of the other. This kind of thinking was deeply embedded in the English legal tradition. The common law had emerged as a system of remedies, not as a body of substantive doctrines. It made little sense to talk about the rules of the common law apart from the forms of action that allow those rules to be enforced. By the 1760s, that view was beginning to change. Blackstone's commentaries marked an important milestone. But the transition was not complete until the 19th century. I'll return to that idea at the end of the talk. For now, the important thing is that the substance procedure distinction was something that had to be asserted and defended in the 18th century, not something that inevitably would have shaped the thinking of contemporary lawyers. That gets us to the third and most important consideration that informed the Whig Compromise, which is the effect of different kinds of transplants on colonial development. So as I said earlier, Tories wanted to withhold English law from certain colonies because doing so would produce a particular set of outcomes. Whigs wanted to extend English law to achieve a different set of outcomes. So in large part, the fight over colonial law was a fight between different visions of empire. But Tories also advanced a second argument, that letting a conquered people keep its own laws would be more tolerant and more humane than imposing English law. So the Whig Compromise was an attempt to counter that argument without sacrificing the developmental benefits of English law. In other words, it was an attempt to be tolerant, in their view, but also economically progressive. So each branch of law that they insisted on anglicizing was thought to have a special importance for determining a colony's economic and political trajectory. So Whigs wanted to introduce civil procedure because it would enable the introduction of juries, which were thought to foster a more active political consciousness. Whigs wanted an English contract law to facilitate trade. And they wanted tort law because trespass suits were the ordinary means of redress against misbehaving government officials. In other words, tort suits had a particular political character. So the Whig theory of legal transplants wasn't really about transplantability at all. It was at its heart a theory about what kinds of transfer would be most useful. There are two reasons why I think this matters. First, it's a case study about how ideas of law develop, particularly in the context of empire. As several sessions today have made clear, practitioners of comparative law have become increasingly attentive to the field's historical relationship to colonialism. And as speakers at the last plenary session pointed out, there has been a general trend in legal history to integrate intellectual history with socio-legal history. But despite those trends, there can still be a tendency to see the story of legal transplants as fundamentally a story about ideas, in which theories of transplantation developed independently of policy concerns, even if they were later taken up by imperialists. So for example, there's a very interesting article from 2010 by Duncan Kennedy that shows how Savigny's dichotomy between family law on one hand and contract and property on the other provided a useful conceptual resource for the high imperialism of the late 19th century because it allowed empires to impose a universal market discipline without infringing on delicate family matters. My point is not that such an approach is wrong, but that we need to supplement it by considering how ordinary lawyers grappled with some of the same problems dealt with by those great theorists. And by the way, I'm not the only person at this conference making that move. Ron Harris's presentation today did something similar in his history of company law in the later British Empire. Second, the story sheds new light on the transition of the common law from a system of writs to a body of rights. As Amalia Kessler and others have shown, that process was not complete until the 19th century, and it had many causes. But as Dan Holzebach has argued in the context of the early United States, the experience of empire was a crucial ingredient. My paper today reinforces that view and carries it further back in time. It also offers a friendly amendment to it. Holzebach argues that in the early United States, the desire for legal uniformity is what helped cause the emergence of a new substantive body of law, or substantive view of law, rather. The British experience, in contrast, highlights the importance of legal difference as a crucial ingredient in the transformation of the common law into its modern substantive form.
Okay, so am I just taking over for you, Christian? Is that
yes, please go ahead. Yeah.
Okay, great, thanks. Well, thanks for the invitation to share, and it's great to see everyone. Great to see you, Will and Fadzila. I wanted to talk a little bit about something that somewhat surprising that I discovered in researching the book that Christian mentioned that's forthcoming early next year. And then, so the book is about the first US territories in sort of the late 18th and early 19th century. And what I found that was surprising was that federal officials in these regions spent a considerable amount of time wading into and trying to grasp indigenous law, that is the law of the region's indigenous peoples. So I'm going to start off by talking a little bit about why this is surprising in light of the historiography, and then turn to a couple instances of this. So why is this surprising? So for this comparativist group, I think I'll briefly give a little bit of background. So the territories were this sort of somewhat distinctively American solution to the problem of empire in the early United States. And that is that these were spaces that were temporarily under federal control. In fact, they deliberately talked about how it mimicked some of the features of the British Empire. But the premise was that once there were enough free white settlers, 60,000 was the cutoff, they would then be admitted on equal footing with existing states. And so, as the structure suggests, settler colonialism, this idea that scholars have pointed to, the idea that settler polities were predicated on the erasure of indigenous peoples, the whole premise of settler colonialism was in some ways baked into the territorial system by design. And yet, nonetheless, you find that these same federal officials who are charged with eliminating and erasing the claims of Native peoples nonetheless spend this time sort of wading into and trying to grasp indigenous law. So a couple of examples of this phenomenon that I discovered. One concerns land purchases, and the other involves violence between Native peoples and Anglo-Americans. And I'll just note, because of the comparative aspect of this, I'm going to pitch this at a pretty high level of abstraction so that we're not sort of bogged down with all the names. I'm happy to tell you all about William Blount and Arthur St. Clair if you would like to know about them. But we'll stick with the sort of broad gauge developments. Okay, so turning first to land purchases. So as most of you may know, the United States structured the colonization of indigenous peoples through a series of negotiated land purchases that were then memorialized in these treaties. And in my research, I focused primarily on a set of these treaties between federal officials and the indigenous peoples of the Northwest Territory, which is loosely present-day Ohio, and then the Southwest Territory, what is today Tennessee. So scholars have explored these treaties at length. They have pointed that the sort of all the ways in which their purportedly consensual nature was clearly a legal fiction, exploring the sort of wide range of coercive measures ranging from explicit force and fraud to more subtle forms of coercion that were employed. I don't want to get into that question. Rather, I want to sort of spend time thinking through what I think is a less well-known issue, which is when these federal officials confronted Native peoples and sought to purchase their land, how did they decide which land belonged to which Native nation? So most of us are familiar with these long-standing debates that happen not just in the United States, but really throughout the imperial endeavors of Europeans over whether indigenous peoples owned land, and if so, what property rights they enjoyed. But for the federal officials who had this responsibility to purchase these land rights, these debates actually were largely irrelevant, right? The question was not what rights exactly they were purchasing from the Native communities, although that was an important question that would get litigated later on. But the more immediate question that confronted them was to decide who had whatever form of title they recognized to the particular parcel that they were questioning. Now, it might be surprising to us, especially if we read these sort of settler colonial ideas backward, that they cared, given that a favorite technique of colonizers, not just in the United States, but I think more broadly, was to sort of agree with one indigenous community to purchase lands that actually perhaps belonged to another group or that another group was occupying. And what we see actually is that federal officials actually didn't really want this responsibility to be arbitrating the property disputes between various indigenous groups. In fact, one federal official called the work, quote, tedious and inconvenient, and repeatedly sought to sort of duck the question. Nonetheless, in the 18th century, it mattered quite a bit to federal officials for a couple reasons. One is that Native peoples at this period retain remarkable amounts of power, especially in these borderland regions. And so the federal government is very concerned with establishing legitimate chains of title. The other related point, though, is that Native leaders actually repeatedly demand that the federal government take on this role. And they demand that even when the federal government isn't purchasing a particular parcel of land, they demand that the federal government write the title of the particular Native nation into the resulting treaty, recognizing their title claim. There's actually some very fascinating examples of the Chickasaw war leader Piamingo, who does this repeatedly in negotiations. He goes at the negotiations, demands that federal officials give him a map that delineates the boundaries of Chickasaw territory. And it's pretty clear why he's doing this, right? It's not that Piamingo doesn't know the boundaries of Chickasaw territory. Rather, he's pretty explicitly about his effort to try to make these land claims legible in Anglo-American law, right? Leaders like Piamingo and others had long learned that these sorts of official papers were really useful ways to try to deflect would-be colonizers, or at least make the claims visible to them. And actually, Piamingo basically says as much in these negotiations. Okay. So these disputes confront these federal officials about indigenous property law somewhat unwillingly. And what's striking is that there's really no other basis to decide them other than indigenous law, right? That Anglo-American courts and Anglo-American legislatures don't actually really claim to extend their jurisdiction into this space that was known as Indian country. And so what you end up having is that federal officials end up informally arbitrating which Native group they think has better title based on the representations of these different indigenous communities and based on their often very rough understandings of indigenous law. And so to sort of broadly dichotomize, like Christian, I too found two divergent groups, but I will call those groups a little differently. I'll call one group the ethnographers and the other group the Brightliners. So these ethnographers were, I think, the kind of federal official that we've all encountered in our research. These are the officials who sort of become self-proclaimed experts on the law of the colonized peoples, and then arrogate to themselves the right to sort of decide the legitimacy of their legal assertions. And what I found interesting, although maybe in retrospect not all that surprising, is that the ethnographers tended to be the people who were most aggressive about challenging indigenous land rights. So in one example that I found from the Southwest Territory, the Muskogee Creek Nation would repeatedly argue that they held title to part of the territory. But there was this one federal official who would repeatedly insist to his higher ups that that couldn't possibly be true, that their claim was invalid. And he would point to statements by the Muskogee Creek's sort of rivals, the Chickasaws and Cherokees, to bolster that legal argument. And in particular, what's interesting is that the ethnographers often use a similar argument to dismiss indigenous property rights. And they claim that under indigenous law, that because these indigenous groups had often arrived recently, often as a result of Anglo-American colonialism, that their claims were not actually valid. I will briefly note the deep irony that many of these federal officials themselves, right, had only shown up in these places only a couple of years earlier. They were living in a society that was sort of rapidly expansionist, that was constantly churning, and yet they were using mobility as an argument against recognizing indigenous land title using the concepts of indigenous law. So the second group, what I've called the Brightliners, tended to be more protective of indigenous rights. And they tended to find common ground between sort of Anglo-American common law of property and indigenous property law in ideas of occupancy. So basically they said, well, look, this is a legal principle that both sets of law recognize. And they reason that if a particular indigenous group is occupying the land, then they have a title claim. And actually what's interesting is this is very similar to the way that indigenous peoples actually articulate their property claims, which tend to be fixated on ideas of occupancy. Federal officials, I think, do so not because they are eager to recognize indigenous property law, though. They follow this rule because it has the advantage of simplicity. Although I do think that there is value to them in this idea that there is a sort of shared legal vocabulary that they can deploy here. Okay, so let me now talk about another area where federal officials are attempting to suss out indigenous law very briefly, and that is indigenous law around violence. So if you look at a lot of Anglo-American writings about indigenous law at this period, what you see is a lot of emphasis on the idea that the foundation of indigenous law on violence is this idea of retaliation. That is, crimes committed by one group against another indigenous group or by Anglo-American settlers against indigenous peoples would be responded to by retaliation, not necessarily against the perpetrators, but against individuals who belong to that group. And for Anglo-Americans, they think that this indigenous law is a significant problem because of the prospect of sort of endless cycles of violence and recrimination that they see resulting from this law. So to try to forestall this, federal officials create federal law that they try to criminalize the acts of US citizens against indigenous peoples, creating robust federal law to prosecute these crimes. But these prosecutions are pretty ineffectual, often because of jury nullification. So federal officials sort of grasp around for other methods to try to maintain peace on the frontier. And what they've come to recognize is that the understandings of indigenous law that privilege retaliation are rather caricatured, and that the law on these questions is much more complicated, and that indigenous peoples usually rely on ideas of reciprocity more than retaliation. And so will often permit what one Secretary of War called pecuniary considerations to compensate aggrieved individuals. And so what ends up happening is the federal government starts trying to buy its way to peace by giving Native peoples trade goods for harms that were caused by US citizens. This is not really, I think, as much a choice by federal officials as it is a sort of constraint. It's circumstance. But they do this across the board in a number of areas, right? Not just with murders, but also stolen goods like horses. Actually, there's a robust trade in enslaved peoples, both indigenous and Africans, in which the federal government starts to play this role of building an infrastructure to actually compensate harms. And interestingly, the federal government ends up building an approach that goes both ways. It builds something like a tort compensation scheme for its own US citizens. So just as with property law, I think what we see is that this is not motivated by a particular desire to recognize or entrench indigenous law, but simply it turns out that the most straightforward way to accomplish peace, which really was hugely important, again, because of the power that Native peoples had in this period, was often to adhere to these indigenous legal norms. Okay. So what are we to make of the perhaps somewhat surprising role that indigenous law plays in early federal governance in the territories? So one thing that I at least find interesting, especially in this comparative law setting, is that it suggests more parallels between the US empire and other imperial powers than the literature usually presents. So usually the US gets sort of hived off into the settler colonial category along with Canada, Australia, and New Zealand, but not other colonies like the ones that Christian was describing, where you have a more robust legal pluralism. And I think that's apt, but I do think there are ways in which the US actually is more akin to these sort of legal pluralist regimes than we currently recognize. And we do have, at least, albeit to a lesser extent, I think, than we're going to see with Will or Nurfadzilah's accounts, we do see that the US is in fact engaged in trying to understand the law of the people that it has colonized and use that law as a technology for governance, which, you know, again, at least provides some nuance for this settler colonial model of erasure. The other thought that I'd offer is that the settler colonial model is helpful because it draws our attention to the ways that imperialism shapes US governance, but it also obscures some of the ways that actually that governance actually functioned, right? So erasure, to be sure, required a lot of work, but I think we should also pay attention to the ways that the US had to build out a governance infrastructure, an imperial infrastructure that was not just focused on erasure, but actually trying to deal with the persistence of indigenous peoples and manage the fact that notwithstanding these settler colonial aspirations, they remain, in fact, they remain to this day within the boundaries of the United States. In other words, the settler colonial project fails and the United States government has to grapple with that fact. And I think that profoundly shapes the form that the US state took as well. And I think focusing on this history helps us grapple with that a little bit. So thanks very much. I'm really looking forward to hearing your comments and thoughts. So I guess I pass the baton now. I forget who is next. Will, am I passing the baton to you?
Will, you're muted.
I think I'm next, yes.
Okay.
Okay, thanks everyone. So I'm gonna start with an anecdote that kind of illustrates the puzzle of sovereignty this paper is trying to explore. So this is based on an article that I'm working on, and it's hopefully just about ready for publication. So it's gonna be kind of a high level overview of the arguments of the article. So it starts off with an anecdote from 1821, when this is early on in the Greek revolt against the Ottoman Empire that would become the Greek War of Independence, leading to, as the name implies, the independence of Greece. And it comes when the British ambassador to Istanbul, Lord Strangford, protested to the Ottomans, their de facto foreign minister, the Reis ul Kitab, that he protested the sale of slaves taken from the Greek island of Chios on the streets of Istanbul. And the people being sold were mostly women and children, and to European eyes at this moment, they appeared white, which accounts for their high status and the reason the Europeans were so concerned about them, in addition to the fact that they were Christian. So Strangford protested, and Canib Effendi, who's an Ottoman diplomat, essentially an Ottoman diplomat, responded that the captives taken at Chios were condemned to slavery by the Muslim laws and religion. I'm using the British transcription here, so they turn Müslüman in Turkish into Musliman. Which not only permitted, but enjoined such a disposal of the wives and children of their enemies. He went on to say that even Russia had never attempted to impose on us the principle that we are not entitled to make slaves of our own subjects whenever we wish. And then he also adds, in a cutting kind of aside, that the Christian powers of Europe, without having the plea of law or religion, had for ages tolerated slavery, not because their Messiah commanded it, but because it was a source of gain. That, it was true, England had abolished it, but that it was only of late years that we had found out that it was wrong, and that half of Europe still differed from our opinion on the subject. So I think interesting to see here, beginning with the kind of the Ottoman awareness of European hypocrisy on the issue of enslavement as they're pressing these claims. But what I want to get at with this paper is how it came to be that the Ottomans could articulate this argument that, first of all, Islamic law required them to enslave Greek subjects at this moment, and as if they had no choice about it, that it enjoined them to do this. And secondly, that this action was protected from any external criticism by the fact that they were an independent power. So there are basically two parts to the article here. One of them explores how this law came to be. The other one puts it in comparative imperial context. So I'm gonna move rather quickly over the first part to try to get to the second part, which I think is of more relevance to today's topics. So the Ottomans' official legal framework was the Sharia, the Islamic legal tradition, especially the Hanafi school, and the fiqh manuals that interpreted it. In particular importance to the Ottomans was the Sheikhul Islam, who was claimed to be the most prestigious mufti or legal interpreter in the empire, appointed by the Sultan. And he would issue fatwas or legal opinions in response to questions. Of particular interest to me here are the questions submitted by the imperial court. These were questions asking for an opinion which was not a binding precedent, but was usually treated as authoritative by subsequent Sheikhul Islams over the centuries. So these are not formal precedents, but there is a body of opinions that are generally accepted as kind of almost de facto precedent, even if they are not technically binding on later interpreters. And in many ways, I think the Sheikhul Islam operated something like the Office of Legal Counsel in the US government, in the sense that when there was a thorny legal question, or when the Sultan wanted some doctrinal backing for something he was about to do, you would go to the Sheikhul Islam and present the question. And I think as I'm exploring other work, there was a tendency to not present the question until you were sure what answer you would get, and to present the question in such a way that you would get that answer. So that the Sultans would present questions, and in particular, what I'm concerned about here is the law of rebellion. So like every empire, the Ottoman Empire faced rebellions throughout its history. Some of those were by Muslims, some were by Christians. Occasionally they would have rebellions by Yazidis or Druze. So there's a lot of religious diversity in the empire, and there's a lot of religious diversity among rebels. the Ottoman Empire, as like most empires, could be extremely brutal in putting down rebellions. However, legally, there was a difference when the rebellion was perpetrated by Christians than if it was perpetrated by Muslims. And that is that under Ottoman interpretations of Islamic law, there was simply no legal way to enslave Muslims. If Muslims rebel, they could be criminals. They could be executed. They could be imprisoned to hard labor, but they could not legally be enslaved. Whereas there was an argument available that if Christians, or for that matter, Jews, rebelled, they had lost their pact of protection with the Sultan, or zimmet, and that they were then subject to enslavement. And throughout Ottoman history, there was a strong economic interest in enslavement. The Ottoman slave markets took in many captives from the Caucasus, from sub-Saharan Africa, and also from the frontiers in Europe and the steppes of Russia over the centuries. So there was a demand for enslaved people. And so this demand, coupled with the fact there was a legal option that for some rebels they could be enslaved, created a constant kind of socio-legal tension of, if there's a rebellion, there are always going to be some people, often soldiers on the frontier, often ill-paid, who are looking for plunder and who see the possibility of enslaving rebels as a source of such plunder. In particular, as we move into the 19th century, for reasons that Madeline Zilfi has talked about in other work that I won't go into here, and also for the demise of galleys in the Navy, there is less economic demand for young adult male slaves, like people who are actually fighting in rebellions, and more demand that remains for females, especially younger women and children, to serve in households. So that's where the kind of economic interest becomes, which is why, as you saw in that quote from Janib, he emphasizes the wives and children of the people who are actually fighting. And that's where kind of the action is legally. So the Ottoman Sheikhul Islams have to deal with this question over the centuries of what are the boundaries of what a rebellion is? What constitutes rebellion that allows enslavement? And the rule laid down by the famous Sheikhul Islam Abu Saud in the 16th century is he tries to be fairly restrictive, which is what one expects. Abu Saud lays down the rule in response to a question that, the question he was given in the 16th century, does the Sharia permit the enslavement and buying and selling of those zimmis, or non-Muslim subjects, who rebelled against the Padishah of Islam, the Sultan, and who were suppressed by his order, like other harbis, like infidel inhabitants of outside the empire? In other words, when non-Muslims rebel, can they be treated like enemies and enslaved? And the answer he gave was, if the rebellion necessitates the abrogation of the zimmat, the pact, then yes. But the zimmat cannot be abrogated when they decline to pay taxes, turn out to be thieves and robbers, or take refuge in the mountains because of the Timariyat's oppression. These are local officials. Unless they join the abode of war or make war with us, they cannot be enslaved. So I think we can interpret Abu Saud's view here as being erecting fairly high boundaries around what it takes to lose zimmat and become enslaved. Not paying taxes is not enough. What it takes really is to join with outside enemies and make war on the Ottomans. And this is the interpretation they adopt well into the 18th century, that essentially their subjects are protected from enslavement unless their subjects have basically de facto ceased to be their subjects, have joined with an outside enemy to make war. And this fits very well the imperial milieu of the times, when you have the Ottomans fighting other great empires, the Safavid Persians, the Habsburg Austrians, the Romanovs in Russia. And the real big threat to them is that they're going to lose territory to an empire. So what you do see is that when local elites among non-Muslim populations raise up a rebellion on behalf of an outside power, the Ottomans are willing to say, oh, we have lost that territory. It has left our territory. It has become enemy territory. The people are now subject to enslavement. So essentially, it's gone from being domestic to being foreign. The rebellion essentially is equivalent to foreign war. The challenge the Ottomans face as they move into the late 18th century into the 19th is kind of the age of revolutions, that you have rebellions that are not on behalf of trying to join a foreign power, that are seeking independence. This happens most notably in Serbia in the early 19th century, and then again in Greece in the 1820s. And so in the article, which I will not go into in full here, I trace the ways in which the Ottomans wrestle with this question of when can a population be enslaved if they have not actually joined the enemy? And more particularly, there is always an assumption that males who are taking up arms have become enemies. That's fairly apparent. Someone is shooting at Ottoman soldiers, they're an enemy. But the question, of course, economically, taking those people prisoner is of much less interest. And of course, pragmatically, people who are actually fighting are less likely to be captured than those who are outside the fighting. They're more likely to be killed on the battlefield or to be wounded, which in this era amounts to the same thing. So the question becomes, when can people who are not fighting, especially women and children, be enslaved due to the actions of others in their community? In other words, when can the responsibility for rebellion be imputed to others in a community? And you see that the Ottomans initially maintain a fairly hard line on this, as you'd expect following Abu Su'ud's fatwa. There are a couple incidents in the late 18th century, and then even early on in the Greek War of Independence, when the Ottoman court seems genuinely unsure what to do. And the separate, I'm happy to talk about this in the Q&A, but I have a separate discussion in this paper, and as well as another article I'm working on about when we can see the Ottoman court as legitimately being uncertain about something and seeking real advice from the Sheikh al-Islam, versus when it seems they have a policy outcome they want and the ways they can engineer legal opinions to arrive at that policy outcome. And I think sometimes it's one, sometimes it's the other. It's not nearly as simple as either they are obedient servants of the Islamic legal tradition or that they can totally manipulate that tradition. I mean, this is following in the footsteps of like every other field of socio-legal studies. It's complicated. But over time, they're initially faced with this question of individual versus community responsibility. Over time, it becomes clear that the Ottoman state is, when rebellion rises to a certain level, they want to kind of flip the switch and declare that this is now a community in rebellion, and everyone is fair game. The problem they face then comes in the 1820s, when the entire dilemma of the Greek War of Independence for not just the Ottomans, but for all the European powers, is that the Ottomans will not accept that Greece has actually left the empire. And none of the Europeans quite want to go there either, because they're afraid of the famous Eastern question that if the Ottoman Empire starts to fall apart, it will cause chaos and a scramble for territory. So the Ottomans initially suspect when there's an uprising by Greek subjects that the Russians may be behind it. In fact, the Russian state was not really behind it and had a very ambivalent relationship to it. So the Ottomans, as the rebellion increases in intensity, the economic needs of the soldiers are to say, let's declare these communities to be in revolt and subject to enslavement. But the concern for the Ottomans is, if we do that, the traditional legal interpretation has been, oh, if a territory is in a revolt that rises to a certain level, then we say they have left the empire and they are now enemies. The problem is the Ottomans are now playing in an international legal milieu where European powers, especially Russia, might pounce on that and say, oh, so Greece has left the empire. Well then, it's now an independent state. We can make a protectorate agreement with it and take it under our protection. And the Ottomans do not want to accept that. So they, I think, creatively start changing the language in which they couch their fatwas about rebellion. That Abu Su'ud had indicated that what constitutes rebellion is when non-Muslims raise a rebellion and join with outside enemies. Repeatedly over the centuries, you see that formula, that it becomes not a formal requirement. That's not a necessary condition. It is a sufficient condition for declaring rebellion. But it becomes, in almost every opinion I've seen in the 18th century before the 19th century, it is the thing that justifies enslavement, that these enemies have joined with others. They drop the other indicia of rebellion and just focus on that one in their opinions. And yet, in the 19th century, that seems to drop away because they don't want to accept, because de facto it's not true, that the Greeks have joined with others. So I think what you see, is the Ottomans kind of updating their methods of interpretation of the Islamic legal tradition to fit into an age of where sovereignty is not about what one can conquer, but sovereignty is about what one legitimately can claim. And when it actually matters to have a legitimate claim to territory that you have no de facto control over. I mean, in the 17th century, I think the Ottomans would be happy to say, oh, the people of Hungary have revolted and we've lost them, but we'll get them back. The armies are coming and we will reconquer them. In the 19th century, it's far less certain the Ottomans can reconquer anything they lost, and therefore they need to revert to legal claims in an attempt to hold some sort of tenuous connection to land that is de facto out of their control, in the hopes that perhaps there'll be an agreement someday that will restore it to them. And this, I think, gives the Ottomans an interesting place among Atlantic empires in this era, since this kind of double theory is something that's quite common in the Atlantic. And I think it's actually a kind of a finer point on it than that. So during the 1820s, the British government also wrestled with the status of Greek rebels, much the same way that the Ottomans did, about the same Greek rebels. For the British, the question was that the Greek quote-unquote navy formed by the Greek provisional government was raiding merchant shipping that traded with the Ottomans, including British ships. And the British dilemma was they thought they should legally treat these people as pirates and therefore subject to execution, since they're not serving a sovereign. And yet Phil-Hellenic opinion in Britain did not support that. And they would have, the Royal Navy would have been in political trouble if they just hanged a bunch of Greek sailors who were claiming they were part of the Greek Navy. So The solution by George Canning, the British Secretary of State for Foreign Affairs in the early 1820s, was to declare the Greeks were legitimate belligerents, but that they were not sovereign. He kind of splits belligerency from sovereignty in order to make this point about piracy. And that point comes back actually 40 years later during the US Civil War for Francis Lieber, who probably everyone's familiar with John Witt's work on Lieber. And Francis Lieber actually fought alongside the Greeks against the Ottoman Empire briefly in the 1820s as a Philhellenic volunteer, like many kind of young liberal Germans of his generation. He briefly fought in Greece and then came to the US. And when he was thinking about how to deal with the Confederacy, this issue came back to his mind. And in a letter that he wrote pseudonymously, and I don't know how to pronounce this word, pseudonymously, under a pseudonym, to the New York Times, he argued that the US should imitate the British approach. He said it was a rule of international law that when an insurrection had reached a certain height, the insurgents were entitled to be treated as belligerents, as the British did when they recognized the belligerent rights of the Greeks in their insurrection against the Turks. But by conceding to our adversary the character of belligerent, we admit nothing more than that the insurrection has reached a certain height and do not in any respect admit to its legitimacy. And that is the position the Union actually, of course, in the prize cases actually did adopt toward the Confederacy. So Lieber here is clearly thinking about his Greek experience with the Ottomans. And what I think is fascinating is the Ottomans have come to the same solution from their own side of things by using interpretations of Islamic law to argue that they can essentially extend belligerency, and in particular the legality of enslavement, to Greek rebels without extending sovereignty. And I think that, so they play this double game, and that allows them to then make the assertions that Janib did to the Europeans to say that we are enslaving these people because they are rebels, but that does not give you any rights to intervene and to recognize them as a sovereign, which you might aid legitimately and legally. So I'll leave it there. I look forward to the Q&A. Thank you.
My talk today, based on a chapter of my book, is on comparative law in the colony of the Netherlands Indies, which is now Indonesia. Towards the end of the 19th century, the legal system was akin to an international legal system rather than legal pluralism under colonial rule. The phenomenon was rare and productive since it yielded more discovery of laws and legal systems as colonial authorities acknowledged that their subjects belonged to different nations in the world, although the lack of legal parity ultimately won out. On the one hand, it is strange to talk of comparative law in colonial contexts. Because of unequal power dynamics, colonialists generally do not need to entertain any notions of comparative law that hint at equality between laws and legal systems. There is a clear hierarchy with European colonial legal systems at the top that superseded all other forms of law in each colony. But it is in fact less strange to talk of comparative law in imperial contexts, as we'll see in my paper today. Empires were in theory equal with one another, especially European empires from the late 19th century onwards. Dutch racial ideologies became normative through law when in 1854, the Dutch government implemented a dual legal system for subject populations that was formalized in the landmark Article 109 of the government regulations, which led to a differentiation of laws in 1855 for foreign Orientals, a category that included Chinese, South Asian, Arab, and Japanese inhabitants who became subject to the same laws as Europeans under private and commercial law, but subject to the same laws as natives under public law. Within the group known as foreign Orientals, the Arabs' dual legal status simultaneously situated them apart from the bulk of Muslim subject populations due to their ethnicity, but within local Muslim societies due to their religious faith, which they shared with the group known as natives. In terms of personal law, Arabs were grouped with other native Muslims who were not only subjected to Islamic law, but also local laws known as adat, glossed as customary law. Although it was never determined what local adat should apply to Arabs across the Netherlands Indies. In a way, the category of foreign Orientals emerged as a form of quasi-sovereignty, albeit under colonial rule. The differentiation of colonial populations into three sections, natives, foreign Orientals, and Europeans, gave rise to what the Dutch called quasi-international privatrecht, where each legal system meant for each group was attributed fictional territorial jurisdiction in the colony. So it's hugely complicated. The phenomenon fits what Lauren Benton describes as the emerging model of an international legal community composed of polities recognized as civilized by the societies already considered members of the international community, so mostly Europeans, during the 19th century. The fact that international law, glossed as intergentil recht, was invoked in cases involving natives, foreign Orientals, and or Europeans meant that a conflict of laws was inherent in every case involving parties in different colonial categories. This system is incongruous since international law could only be applied between nations. It certainly did not reach within states because that would violate a state's sovereignty. Moreover, the application of international law assumes that there are identifiable nations within the colony. On a superficial level, it flattered the Dutch colonial government to conceive of the population of the Netherlands Indies as a territorially compact people rather than the sprawling and stratified colony that it was. An optimistic teleology would be that this so-called international legal system was the harbinger of its future actual implementation. It is easy, therefore, to imagine how some of the Arab elite were inspired to achieve actual quasi-sovereignty, a term that refers to the status of sub-polities within empire states that were said to retain some measure of authority over their internal legal affairs while holding only limited capacity to form international relations because they were colonial subjects after all. While extraterritorial arrangements found in Japan, China, and the Ottoman Empire in the 19th and 20th centuries are well documented, aspirations by subject populations in colonies for the status of exemption from the law of the land have not been investigated. Arabs in the Netherlands Indies who comprised 5 to 7% of the population, depending on their location in the vast archipelago, tried to take advantage of the situation. They appealed to Ottoman protection as subjects potentially that led to a paradigm of diplomacy in the colony. This inadvertently allowed some colonial subjects, these Arabs, more latitude than the Dutch colonialists intended for them, since they certainly did not possess equal status with the Dutch. Most Arabs in the Netherlands Indies did not originate from Ottoman Empire proper, since they did not come from places like Baghdad or what is now Turkey, but from a place called Hadramaut in present-day Yemen, where Ottoman hold was tenuous. Although in 1872, the Ottoman Sultan did install a governor for the Hadrami coast. It's near the coast. Hence, Dutch authorities believed that the claim of Ottoman subjecthood amongst these Arabs in the Netherlands Indies was weak. This did not stop several Arabs in Batavia, which is the Dutch capital city, which is now Jakarta, from claiming European status after pledging their allegiance to the Ottoman Sultan in the 1880s, despite having never even lived in Hadramaut. After all, the Ottoman consul in Singapore, which is a British colony, since 1864, was an Arab from Hadramaut, they claimed. And the Arabs in the Netherlands Indies even started to produce certificates declaring European origin. And this is because the Ottomans were regarded as Europeans by the Dutch in the Netherlands Indies and also back in the Netherlands. To complicate matters, although Dutch authorities in Batavia refused to recognize these claims of Ottoman subjecthood, they vested Ottoman authority in the 1880s with a legal hold over Arabs of Hadrami descent based in the Netherlands Indies, but only with regards to their property in Hadramaut. So, these Arabs had a claim to Ottoman subjecthood in that sense, in that very narrow sense. In this way, laws governing personal status was divorced from laws over property, a move that we see in many colonial arrangements throughout the world. Thereafter, the Dutch government instituted that legal documents such as powers of attorney not only had to be approved by Qadis in Hadramaut, but also had to be ratified by the Ottoman consul in Batavia. Already robbed of his diplomatic status amid strained relations between Dutch and Ottoman authorities, the Ottoman consul now had to suffer the indignity of verifying the authenticity of seals and signatures on documents that originated in Hadramaut. This requirement, not surprisingly, resulted in several complaints from members of the Arab community themselves, who argued it was ridiculous to expect the Ottoman consul to have knowledge of Hadramaut and the Netherlands Indies because neither was legally Ottoman territory. So now they play, this other game due to this stipulation, which was onerous. Rather absurdly, the Ottoman consul often had to consult the Arabs themselves, since he had no way of verifying anything by himself. Worse, there was a hefty fee for the Ottoman consul's legal services, between 40 and 50 guilders, an amount often worth more than the real estate property in question. Because the legal system in the Netherlands Indies was highly localized, documents deemed valid in Batavia were not automatically regarded as valid elsewhere in the colony, such as in the neighboring city of Surabaya on the same island of Java. So this Kafkaesque jurisdictional situation led to inconsistency that could be exploited by colonial subjects to continually negotiate their status. European status was highly desirable to Arabs, who were acutely aware of the inferior status that the classification of foreign Orientals conferred on them. Legal parity in the courtroom remained for the most part only theoretical under any circumstance, because the application of different laws to foreign Orientals stemmed from a lack of trust by the Dutch that had to be mitigated by precautionary measures not applied to agreements with other populations. So they were actually worse off than the natives. In a few instances, Dutch courts were willing to embark on a journey of discovery of foreign laws, with the possibility of enacting them in the colony, because Arab foreign Orientals were regarded as aliens in the colony, actually. That's why they were called foreign Orientals. There was a case involving a power of attorney in 1919. It might appear ludicrous that this effort at discovery of laws should be undertaken seriously as late as 1919, 3 centuries after Dutch rule was established in Java. But the phenomenon also coincided with the Dutch court's keenness to underscore the legal fiction that Arabs were foreigners in the colony, a recent legal development that emerged in the 19th century, the mid-19th century. There was a case of suspected forgery of a volmacht, which is a Dutch term for power of attorney, created by an Arab woman. And this case involved an Arab translator who was most probably corrupt, who claimed that Arab women cannot write Arabic, which is untrue. He claimed that the power of attorney that the woman supposedly produced was most likely a forgery as a result. The Dutch court unexpectedly declared that it was presumptuous to simply apply Dutch laws of deeds and contracts to these foreign powers of attorney that originated somewhere else. The court decided that laws applied in the land of origin of parties involved, in this case in Hadramaut, should also be considered. The court was willing to embark on a journey of discovery of foreign laws with the possibility of enacting them in the colony because Arab foreign Orientals were regarded as aliens in the colony. Though the Dutch court did not explicitly admit as much, it could be argued that these doubts and this attempt at discovery of laws of another place arose as a direct consequence of the translator's testimony that Arab women could not read and write Arabic. If what the translator said was true, what did this mean for the powers of attorney created by women already circulating in the Netherlands Indies? The dystopian image of a crumbling legal world built on paper was too much for the court to bear, so it swiftly displaced its anxiety onto the problem of personal jurisdiction, necessitating an attempt at discovery of laws. Dutch authorities were ready to project law regarding powers of attorney as practiced in Hadramaut to Arabs residing in the Dutch colony and to accommodate this law within the framework of legal pluralism. To their disappointment, however, they discovered that the laws of Hadramaut, which was based on Islamic law, had little to say about procedure regarding written contracts and proxies, since oral testimony and contracts were valued more highly as evidence over there. They further discovered to their dismay that in several Muslim countries, Qadis gave almost no weight to written evidence at all. Slowly over time, due to mercantile wealth obtained in the eastern part of the Indian Ocean in Southeast Asia, and the power of bureaucracy that comes with this wealth accumulation, written evidence became more and more acceptable in Muslim jurisdictions. Colonial authorities shared the opinion that territorial fixity of jurisdiction applied to powers of attorney. In matters concerning documents and contracts, Islamic law was not to be generalized in the scrutiny of legal documents. Instead, it was the law of Arabia, of Hadramaut, that took hold, as we have seen. So this is one of the reasons why attempts at enacting comparative law failed in the colonies, because territorial jurisdictions were the primary form of jurisdiction, not personal jurisdiction actually. So colonial law reigned supreme in the colonies right up till the end. My book, especially this last example, also shows that people remade Islamic law all the time. It seems to me that the barrier to studying Islamic law within comparative law perspective is the fact that it's perceived to be deeply religious up till the modern period, and therefore incommensurably different from other legal systems. Islamic law does enter the study of comparative law through widespread European colonialism in this very particular way, but common way. This is a phenomenon that's unavoidable in history and something that historians should take seriously and not take it as a corruption of the Islamic legal tradition, because they would assume that a pure version once existed. Especially because European colonization of huge parts of the Islamic world resulted in the production of new colonial Islamic laws, which post-colonial nation states inherited. Thank you.
Right, thank you very much. I think the floor is now open for questions. If you want to click on the raise hand function or chat, or just turn your video on and start waving. Go ahead.
I'll ask a question just because it seems to be called for. But one of the things that I'm very interested in, it's not directly related to any of these papers, but I think it's tangentially related to all of them. And so this is really a question to any of you, is how the concept of legitimacy plays a role in these assertions of imperial authority. It seems to me that every legal system rests on some kind of claim to legitimacy. And I wonder how these legitimacy claims of emperors or imperial powers relate to the various topics that each of you have raised.
I'll jump in, I think. I think that the Ottoman state producing legal justifications for enslaving its own subjects was vital to legitimacy. And you see this frequently in Ottoman opinion. Like, the reason the state looked for legal opinions was for legitimacy. I mean, I think there was also some genuine ethical concern by state officials that they were doing the right thing and following their legal and religious commitments. But it's, practically, there's a concern about legitimacy, most obviously among Muslims, that the state should be seen to be following the Islamic legal tradition. And I've seen other instances of writing about captivity and slavery more generally that when the state is not seen to be doing that, there's protest. But interestingly, there's also a sense that non-Muslim subjects will respond to this. There's one incident that I come across where the Ottomans dealing with a revolt along the Danube, and a number of Moldavians are joining the Russian army. These are Moldavians being in what's a part of what's now Romania, joining with the Russian army. And the Ottomans decide, we should capture these people and put them to work rowing on galleys, when they still need some galleys at this point. As punishment, but also legally they are slave. They can be enslaved. They can be taken as slaves of the state and put to work what the state needs them doing. But then there's a concern that a crowd of people may gather and protest, especially that non-Muslims may protest, saying you were violating Islamic law. The sense that the Islamic legal prohibition on enslaving subject populations, zimmis, is a constraint on the state that the non-Muslims will stand up for, sort of as if it gives them almost as if it confers rights upon them. And that will be diffused by a fatwa from the Sheikh al-Islam, they think. So the sense here that like Ottoman Muslim officials interpreting Islamic law will provide legitimacy among non-Muslim populations, which I think is an interesting insight into the shared nature of Islamic law as kind of like, as Baki Tezcan has suggested in other contexts, it's like almost a constitution, an imperial constitution, that there are certain constraints that the state has to observe that all subjects are going to expect.
For the Dutch in Indonesia, they also underwent a crisis in the sense that they wanted to, from the mid-19th century onwards, they took their civilizing mission seriously, and that was at odds with the level of oppression that they imposed on colonial subjects, and therefore they tried to differentiate the different colonial subjects in terms of level of civilization. So they started with promoting the Japanese to European status. So even within the category of foreign Orientals, the Japanese were regarded as the most civilizationally advanced, and so on and so forth. So that's where they had a crisis of legitimacy, in the sense that they were trying to civilize people, but at the same time, they were oppressing these foreign Orientals the most out of the, more so than the natives, in fact. So they had to, their solution was to raise some foreign Orientals to their level, the level of Europeans, and wait to see who else will rise up to this in their eyes.
In the British Empire, legitimacy works pretty differently as a concern in different places. So in Quebec, for example, there's no question that the British are there legitimately, because they had simply just conquered it from France. And they won this in a pitched battle on the Plains of Abraham, which is exactly how you're supposed to get territory in the 18th century. And so everyone agrees that British are there legitimately. The question is, what does it mean to rule well? But that's not quite the same thing. It's more complicated in Bengal because there are multiple layers of sovereignty going on. So formally speaking, the British have only de facto sovereignty. Formally, the Mughal Empire still exists. The British basically have a grant called the Diwani, which allows them to collect taxes and administer justice there. And so there are questions about how much wiggle room do the British have to change Mughal law, for example. Do they have to rule in accordance with the what is called the ancient constitution of the Mughal Empire? There's another question that comes up about the fact this is, that empire was a minority Muslim empire over a majority, what we would now call Hindu population, although that term wasn't really used then. So there's another current of argument about legitimacy, which says, no, we need to rule on behalf of the people as a whole, and that means maybe downgrading the role of Muslims. And then there's a third argument which comes in, which says, no, we're also conquerors of Bengal, whatever the Mughals say, they might pretend it's a grant, but this is a conquest, and therefore, to be legitimate British rulers, we've got to impose our own law under the terms of the British Constitution. So there's these different sort of ways of articulating legitimacy in South Asia, which don't really apply in the same way in North America.
I'll just say very briefly, I think we're more familiar, those of us at least who live in the United States, are these legitimacy arguments sort of swim still in the political ether. I think there's two legitimacy arguments that emerge from the American Revolution that are actually in tension about the right to sort of govern indigenous territories. So one is the consent-based argument, right? The idea that Native peoples have consensually transferred jurisdiction. This is obviously a legal fiction in all sorts of ways that I traced, but it rests on this idea that this has been a consensual transfer of both territory and authority. The flip side is something predicated more on popular sovereignty. And it seems a little odd to, I think, our present day conceptions, but states take very seriously the idea that their act of constitution making and the definition of the boundaries of the state through a popular process confers on them jurisdictional rights over that space, notwithstanding the fact that indigenous peoples never consented to be included with that and are not included within this conception of popular sovereignty. Where I think these two, what's striking is that these two different conceptions of legitimacy actually collide over the course of the early 19th century. And one way, I mean, to think about the process of what gets euphemized as Indian removal is to think about it as the collision between these two conceptions, right? That there are the opponents of forcibly removing the native nations of the Southeast point very strongly to these consensual ideas, whereas their opponents, including Jackson and others, point very heavily to these sort of popular sovereignty-based justifications.
I'll take the moment to jump back in actually and say that I think what I'm seeing connects up to what Christian has talked about at different sources of sovereignty, that I think the 17th century Ottoman Empire was very happy with the conception that sovereignty based on conquest is supreme and almost the only form of sovereignty. The 19th century Ottoman Empire is much more insistent that there is some sort of legal title that can attach to sovereignty, that, you know, that conquest might not remove title entirely, at least that they're losing, so they have a vested interest in that. And they succeed in the mid-19th century in obtaining a guarantee from the European powers that their sovereignty will not be infringed, which means that when European countries do come along and nibble off parts of the Ottoman Empire, they're very careful to do it under arrangements that are not expressly based on conquest and claiming sovereignty. Like when the British go into Egypt in 1882, as Amy Janelle has written about, they're very careful not to argue that they are, you know, taking sovereignty over it, because that's a no-no under the Treaty of Paris, but that they have other ways of doing it. So I think the change in law rebellion tracks that they are re-articulating it for a world where they want to claim sovereignty based on things other than conquest.
Actually, if there's no one else to jump in, I have a question that we'll try to put Greg's and Will's papers in conversation. So, Greg, a lot of what you're talking about for interactions with various Native peoples remind me of sort of conversations about the Alien Tort Statute in the U.S. and this need to sort of compensate, foreign governments, or whatever, or foreign citizens in order to avoid international conflict or whatever. And so I was wondering, in the American Indian context, do emerging debates about the U.S. and the world stage end up informing how, for example, the Brightliners think about occupancy, or is that purely a domestic law that's being projected into Indian country? And then it sort of ties into Will's idea about the interaction of international and we might call domestic Sharia law.
Yeah, so briefly, I would say what's striking is it's different sets of people who are doing the thinking on these questions, right? So you have, some people like, say, Secretary of State Thomas Jefferson end up doing a lot of thinking both about indigenous peoples and about foreign relations. And so you see the most robust development of sort of international law comparisons in Jefferson, for instance, and his writings on the topic. The people who are actually doing the underground negotiating, and even their higher ups, tend to be in the War Department. And so you have a very different set of mentalities from the people in the War Department. I spent a lot of time in the papers of Henry Knox, who, what's interesting about Henry Knox is he has a pretty robust set of thinking on the question of sort of what gets called Indian affairs. But he doesn't have the same legal background as someone like Jefferson. So he's not plucking principles from Vattel in the way that Jefferson is. He doesn't have that same vocabulary. Where I think you see more commonalities, less in the Alien Tort Statute than in concerns about compensation, say, under the Treaty of Paris that ended the American Revolution. There's all these ongoing disputes about both confiscated loyalist property and the status of enslaved people who have been sort of expropriated in the course of the war. Both sides are seeking compensation from each other. And so I think there's a sort of general sense of the role of compensation in conflicts and the role of governments sort of trying to make their own citizens whole and maintain peace through these practices of compensation. It's always, but I always am wary of arguing too much that they're sort of drawing from first principles in the context of relations with native peoples. I think it's really important to stress how much of this is sort of ad hoc and improvised, which is one of the reasons I think that Indigenous law ends up having so much space, is because the stricture, there's the Anglo-Americans are less wedded to adhering to a particular set of legal norms. They're willing to sort of engage, particularly these federal officials see this as a space where they can make law more readily without having to sort of adhere to the diplomatic niceties that they might adhere to in negotiations with Europeans. That, of course, ends up having disastrous conflicts for native peoples, but it also provides some space for indigenous legal orders.
And for the other two speakers, were there also sort of bifurcations in personnel? Or are the same people thinking about, what is the content of Sharia law and what is the content of international law in the Ottoman Empire? Are the same people thinking about sort of colonial administration and what counts as international law or private international law, say in the Netherlands? Or are these also just different sets of personnel?
In my
Cynthia,
case,
you want to go
it
first?
was, yeah, sorry. In my case, it was the same people who did both things at this time. It was because there were people who were confident enough to deal with Islamic law at this level, not just at the level of personal law, which is usually family law only, like in the British Empire. So the Netherlands, the personnel in the Netherlands Indies was very different from, because my book is a trans-imperial story. It's very different from the British territory, where the judges were, they were experts on family law only. They know it very well in terms of Islamic law, family law only. But in the Netherlands Indies, there were people like Christian Groningen, who were adept at both international law and Islamic law. It was really amazing. And he's the one who was advising the Dutch colonial government on all these matters. Yeah.
So for me, I think it is largely the same people. I mean, the Ottomans don't even have a formal diplomatic corps in the 18th, early 19th century, although there's a certain set of scribes who are essentially do that job. And the job of Ra'isul Kitab, or chief of the scribes, is de facto a foreign minister. That's the thing. There's a lot of things scribes can do, but the thing that he does really is foreign relations, not so much other scribal work. It's like a 16th century title, maybe even 15th century, that gets adapted to this. Later in the 19th century, as Amy Janelle and also Will Hanley, who I see on this call, has written about, is there's the Ottoman Foreign Ministry forms a committee of legal advisors, the Istishare Odasa, who are initially Europeans they hire, then Ottomans, Armenian and Muslim, trained in the British Empire, in European states, to deal with questions of international law. But it's all the same people. And I think it's actually beyond the same people. There are cases, and I'm writing about this elsewhere, where the Ottomans will turn to the Sheikh al-Islam to interpret treaties, the language of treaties, kind of ordinary treaty interpretation, not on the theory that there's anything particularly Islamic about them, but on the theory that nothing the Ottoman state does can contravene the Sharia, and he knows how to interpret treaties, law, and law is law. There's kind of a sense of unified law, that the Ottoman obligations are all one seamless garment, sort of, and like there's no way to pick apart what's a domestic obligation and what's a foreign obligation, that law is law, which is an interesting change from a couple centuries earlier, when the Ottomans had a sense that there was Sharia and there was Qanun, the kind of imperial law, or you could say like imperial custom. And there was a separate official, the Nishanja, who was seen as the master of the Qanun, and you'd refer things to him to interpret Qanun, whereas you'd refer Sharia questions to the Sheikh al-Islam. By the late 18th century, the Nishanja is still around, and he's still signing treaties and actually negotiating treaties. And yet there's a sense that somehow the Sheikh al-Islam is really the final authority, almost as if like, and this is not formally done, but I almost get the sense that like there's been some sort of mental reorganization, that the Nishanja was like the court of final appeal, and now he's been put under the Sheikh al-Islam as the kind of supreme interpreter of all law, which is interesting. It might tie into an idea put forward by Baki Tezcan, that by the late 18th century, the Ottomans kind of there's a resurgence of Sharia as a unifying principle of law. And I think you see that here, the idea that you can refer a treaty to the Sheikh al-Islam for interpretation simply because he is the guy who handles law in general.
So I'll ask a question if that's okay. I was curious, particularly with Will's paper, but I think you know, it runs across, particularly maybe in Christians. Thinking about you know, what struck me in your paper, Will, was this question of the similarities that you see emerging between the sort of Atlantic Empire's treatment of the questions of belligerent rights and the Ottoman conceptions. And to what extent you think that is, I think this is often a question that emerges in these debates about sovereignty. I mean, how much do you think they are informing each other? And how much of this is a set of common problems present a, you know, result in a set of similar solutions? So, you know, I'm curious about that, but I think there are some elements of that in the other papers as well.
It's a hard one for me to answer definitively, I think. I think there's both going on. I think there's an increasing awareness by Ottoman officials in the late 18th century of what Europeans are saying. But at the same time, I think it's also a question of common problems. I think the unifying factor might be the sense that, I mean, I'm thinking here of like David Armitage's work, that the common problem is that of secessionist rebellions, the idea of new states, which is itself a matter of ideas moving from place to place. Like the ideas, I think, are in some ways at the core of the common problem. That there are, again, the Ottoman Empire, like every empire, has revolts throughout its history. What's special in the early 19th century is the idea of independence movements, which is an idea that, again, like the discontents that drive the Greek War of Independence are in no way new, and they are in no way unique to Christians in the Ottoman Empire or to Greeks. But the idea that gets in there, not at first, but as the revolt goes on, the idea of forming an independent country that is kind of a nation state is something new. And so that way, I think the common problem is an idea that moves around. And again, I should say problem from the perspective of the imperial authorities. You know, the guys I'm reading, that was a problem. For the Greeks, it's not a problem. But in terms of the imperial responses, I don't see explicitly kind of like, oh, we need to do what the Europeans are doing. But I think that European ideas and vocabulary provides a useful way to deal with these problems as they emerge. I think there's some sense of like pragmatic adaptation that would have, if you could run the experiment without European contact, somehow like the Ottoman officials didn't know anything about the Atlantic world, they would come to some of these ideas. But I think some of it is also kind of conversation. The French Revolution plays a role here. Pascal Fergus has written about this, that the Ottomans are quite aware of developments of the French Revolution, and the idea there of kind of like nation states, liberty, independence is something that is trickling into Istanbul, and they're thinking about in this era.
Yeah, I mean, the British in the 18th century are very much thinking about what other empires have done. In part, this just happens to be a time when people get interested in the question. So this is when Gibbon is writing about the decline of Rome, for example. So it's just part of the intellectual life. But it's also because they're interacting, you know, in most of these colonies, they are a successor empire. And so they're interacting with people who have lived under the previous empire and perhaps still claim authority from the previous empire. So you still get letters from, say, a former or current Mughal official saying, hey, you can't do English law here. This has always been done according to Sharia. So you can't bring in your own arbitration system here. And so therefore, British officials have to react to that in some way.
May I jump in? Will Hanley said that he had to go, but he texted me a question to throw out to the group. He said he couldn't send it generally. He had to send it to someone because he's not a co-host. So he said, I wonder if comparative law paradigm offers anything useful to historians of imperial law nowadays. It seems like the story we tell are swamped by power imbalance. We easily see our actors recognizing counterpart laws on all sides of imperial divides, but it's all dominance and not much comparison. And he says, thanks for the panel. I need a minute to think about what I would say in answer to that. So if anyone wants to jump in. Yeah.
I can start. In terms of, yeah, sure, there's the power imbalance is there, but it's remarkable that colonial subjects themselves felt empowered to speak back due to the changing circumstances with changing administrations, colonial administrations. So like, for example, in the Straits Settlements became a crown colony ruled by the colonial office rather than the India office, and that was seen as something, a new moment. And the Arabs there too seized the moment by asserting their own authority, you know. So there are these moments where people manage to, you know, this is the story. The interesting thing is that these colonial subjects also spoke the same language in terms of civilization, you know, in uncomfortable ways, basically by denigrating fellow colonial subjects. Like, we are better than them, and therefore we should be raised to a higher level in your eyes, the European colonialists, you know, and so on and so forth. The other one thing that also struck me about, you know, when Greg asked the question just now, is the fact that the colonialists often shared knowledge of each other, but they're not interested in the content of specific laws. So they're not like, you know, the Dutch were not interested in how Islamic law is practiced just, you know, a day trip away by boat to Singapore, where there were Southeast Asian Muslims, and how the British were doing it over there. The Dutch were more interested in learning about how the British did implemented Islamic law, administered Islamic law in India, because the Dutch had a huge colony in the form of the Dutch East Indies with a lot of Muslim subjects. And so they compared themselves not with this tiny colony, you know, the Strait Settlement, Singapore, and so on, but with India, you know. So they were interested more in management of law, you know, and not so much legal content in the sincere comparative law sense. Yeah.
I'll just say quickly, I mean, the power balance was particularly glaring, I think, in my case. And I think the comparisons are useful in a couple sense. I mean, one, there's the question of the comparison between the United States and other imperial regimes, which I think is important and which I think has been underdeveloped, particularly by US historians, and not taken as seriously. But the other thing that I would say is that what's striking to me is that, yes, there's the clear power imbalance, but it is striking to me both how much both indigenous peoples are thinking through their own legal systems with respect to Anglo-American law, and also the extent to which the United States is thinking through its own legal system with respect to indigenous law. And this is not a nuanced account, particularly on the Anglo-American side. And yet the fact that they need to do this repeatedly and that they're trying to puzzle through it, I think is significant, right? And there is a way in which, yes, it tells us much more, arguably, about Anglo-Americans than it does about indigenous peoples in their portrayals of the laws of the native peoples they encounter. But I think it sort of suggests, you know, the significance of this legal encounter, notwithstanding the power imbalance for how Anglo-Americans were conceptualizing this category.
Yeah, no, I think that very much applies to the British situation as well. Again, I think that it redefined both sides of the encounter. So both it changed how Britain thought about the common law, and of course it also, in an arguably more profound way, changed in British India notions of what became known as Anglo-Mohammedan or Anglo-Hindu law. I mean, there are some people who would argue even that the notion of a single coherent Hindu law was born out of the British colonial encounter. So it's worth studying for that reason. But also, I mean, the fact that there was a power imbalance in some ways is the reason to study these encounters, because power imbalances have not disappeared. And so learning sort of how these work in the real world and the choices and the range of choices that different actors on different sides of that imbalance have to make and the consequences of their decisions, I think remains a relevant thing, even if the form of empire has changed.
I think you could simplify my story quite easily into a story of changing Ottoman Empire, losing power, and changing their legal interpretations. It can be a little bit crude, you'd lose something, but that's something of the overall motif, in a sense. That as the Ottoman Empire loses power vis-a-vis other empires, it changes legal interpretations in an effort to maintain power over subject populations. The power imbalance there. I think questions of comparison are a little trickier for me because everything I've talked about in this paper is public law. I mean, the law of enslavement in some ways is private law, like that's kind of like par excellence. The idea is to create dominance by one subject over another. And yet the law of how one becomes a slave is kind of like paradigmatic public law, especially when it's related to rebellion here, which makes the comparative story it's hard, means it's very difficult to disentangle, I think, the comparison from the power, because the people doing the comparison in my story are always state officials, and the state is what has the power to make these interpretations. So it's a little harder. There's not, in some ways, it's not like a three-pointed triangle of like, you know, one legal system with actors, another legal system, and someone comparing. It's like the people comparing are the ones who are, in my story, always trying to manipulate their own legal system and adapt it. So it's a little trickier, or maybe a little simpler if you want to look at it that way. Like, you can't possibly abstract out state power from any of this.
All right, that brings us to the end of our time. Thank you to everyone for listening and watching, and thank you to my fellow panelists, and enjoy the rest of the conference.